The Electoral Commission says it's now going to seek advice from either the Constitutional Court or the Electoral Court on the report by the former Deputy Chief Justice Justice Moseneke. That report recommended that the local elections scheduled for October be postponed due to the COVID-19 pandemic, saying they won't be free and fair under current conditions.
Ladies and gentlemen, it's important that we understand that until a court of competent jurisdiction has determined the application for deferral, all other planned electoral activities will proceed. And the Commission appeals for the spirit of calm, support, and working together among all the stakeholders in the interest of stability and certainty on one hand, and the indispensable need for the preservation of constitutional democracy in the Republic.
Meanwhile, the Commission's also adopted the report's recommendations.
The Commission, in response, unanimously accepts the findings of the Moseneke report. In particular, the Commission notes the rational and central thesis of the report that community immunity through mass vaccination must be considered as a desirable step in the conduct of a safe, free and fair elections in the Republic. Insofar as the recommendation pertain, the Commission will adjust implementation to accord with current legal prescripts and financial means. Where there are substantial financial implications, National Treasury will be approached. For its part, the Commission has determined immediate causes of action given the agency of the matters canvassed in the report.
Well, there's a lot of law, there's a lot of politics to consider with this. Professor Pierre is a constitutional law professor at the University of Cape Town. Professor Ivor Sarakinsky is at the Wits School of Governance. Gentlemen, good afternoon to you both. Professor if I can just start with you. The recommendation from the panel is that there be a delay in the elections, that the Electoral Commission approach a court to get permission for that delay. It seems to be working on the assumption that judges at the Electoral Court or the Constitutional Court will allow the delay. Is it automatic? Can a court really grant a delay in our elections that easily?
Well, if the election was a by-election and it was within the 5-year term of the municipal council, that could easily be done. You don't even need to go to a court. But here we have both the Municipal Electoral Act and the provision in the Constitution that says that the election must happen within 90 days after the 5-year term is over, so before the 1st of November. So I am not sure that, well, firstly, the court has never done what they are going to be asked to do, namely to suspend a binding provision of the highest law in the country for a specific period of time. And also, if they are going to do so, they would need to have extraordinary evidence, I would think, that this is the only way for there to be a credible election. Whether that evidence exists, I'm not so sure. It's going to be very difficult for the court to make this decision, but they won't just do it automatically. It's not a done deal.
So just to understand it, and I'm going to ask you to speak up a little bit. It's not the clearest sound coming from your system, I'm afraid, but the Constitution says, and the Constitution is very clear on this as I understand the clauses, you must have an election within a certain time frame. And that's really fundamental to our democracy. It doesn't say you must have an election inside a certain time frame if it's safe. It says you must have the election within a certain time frame, sort of full stop.
Yes, so the Constitution doesn't provide any qualification or any avenue out. So that is the problem that they're going to face when they go to the court. The court is going to say, well, we are bound by the Constitution. It's the highest law. If you don't like it or if there's a problem, it needs to be amended. But why is it that we have the power to actually basically change the Constitution for this particular period and waive one of the fundamental principles that is also a founding value in the Constitution of regular elections that would normally require 75% majority in the National Assembly to amend it? So they are asking the court really to do something really unprecedented, and it's going to be very interesting to see how the court responds to this.
Professor Sarakinsky, there's another sort of angle to this, which is where the law and the politics sort of collide. Now, it might be a happy collision, but it can also be an unhappy collision. So you could have a situation where 11 people who are not elected, I'm talking for argument's sake the Constitutional Court, make a decision that the 40 million people who are eligible to vote don't vote. I think many people might feel that that would be unfair.
Very unfair and very problematic. And in terms of context, the Constitutional Court and the courts in general in South Africa have been sucked into politics because political parties haven't been able to sort out their differences in Parliament through deliberations, through voting, and agreeing in terms of the passage of legislation. And that means a whole lot of really controversial issues end up in court and end up in the courts becoming highly politicized. And I'm afraid this is one more example of that. This is maybe even more serious than the others because it means that the judiciary is going to be responsible for stopping an election. So it brings into question separation of powers. It brings into question democratic values and practices embedded in the Constitution as already discussed. And it would be very problematic for 11 justices to make a decision on this.
Does public opinion matter, Professor Sarakinsky? And let me explain what I mean. I think it's the HSRC that did some surveys on this. I don't know how scientific they were, but I'd like to trust the word of the Human Sciences Research Council. They said that it was a majority, over 60% of people believed the elections should be postponed. Now you'd think, well, maybe if the majority wants to postpone an election, that's fine. But I'm sure there are complications. So, for example, just as a hypothetical, you could have a situation where the majority of people in 8 provinces want to postpone an election because they don't like what the outcome would be in one province, whereas the people in one province would want to have an election. They would still have a right to have their election, wouldn't they?
Yeah, I don't think that a decision like this can be made on opinion surveys and public perceptions. If we held a survey tomorrow on reinstating the death penalty, 90% of citizens would want the death penalty back. And for a whole range of arguments in terms of jurisprudence and values and human rights, that is a demand that can't be accommodated in our constitutional order. And I think the same principle applies to postponing election. Just because large numbers of people allegedly want it doesn't mean it's the right thing to do, and it certainly doesn't mean that it ought to happen in that way. I think there are far more and many more variables that need to be factored into how to proceed forward than just accepting a simple opinion survey like this.
Professor De Vos, there's a situation where the argument could go like this, and this is the argument that could be presented, or could be presented by lawyers on different sides, or lawyers on the same side even, to the Constitutional Court. They could say that to have an election now would result in a situation where the election is not free and fair. And in fact, that's what the former Deputy Chief Justice Moseneke said. They would say you can't have proper campaigning, people can't go door to door, there's no way that new parties in certain areas could go and make themselves available to voters, they wouldn't be able to campaign. So the election wouldn't be free and fair. So it would be unconstitutional for that reason. But it would also be unconstitutional to postpone the election. So what then?
Well, that is true. That's why the decision, either way, there's not really a good option here. There's not a magic way of resolving this that is a win-win for everyone. But I would say the problem with that argument might be that it is not clear on the evidence that it's going to be impossible to have a free and fair election. Our law doesn't require that the election must be perfect. It requires, the Constitutional Court said, that political parties must be able to campaign. But as Justice Moseneke also said in his report, whether the campaign happens now or in February, that campaigning will to some degree be restricted because of COVID. Whether we are in level 1 or level 4, there will be restrictions. So that in itself will not make the election unfair, and people must be able to vote. So as long as all the conditions are met for safe COVID safe measures are in place, it is not clear that it will be impossible for people to vote. Some people might not go and vote, which otherwise would have voted, but that in itself does not make the election unfree and unfair according to the standard the Constitutional Court has set. So I think that that's going to be very difficult for the IEC to get around when they go to the court, because the court's going to say, do you really have proof that the election cannot possibly be held and be more or less free and fair?
Professor de Vos, I do want to stay with you on this because you've read, well, I think all of the Constitutional Court judgments, if I remember correctly, and probably read them more than once. I've read just some of them. There have been situations, if my memory is correct, where the Constitutional Court has temporarily accepted the illegality of something. So often a certain law will come before the Constitutional Court and they'll say this law is unconstitutional. We give Parliament 2 years to fix it. And one of the consequences of that is the Constitutional Court is saying on the one side, this is wrong, but we're going to allow this wrongness, this illegality, this unconstitutionality to exist for 2 years while you fix it. I mean, a good example is actually around voting laws at the moment. This is one of those judgments. There have been others. So Parliament has given time to fix things. Another precedent that maybe is relevant, maybe isn't, is in one of the social grants cases, and there were many of them, but the company that was paying the grants, it was, I think, an all-pay case, was paying the grants, was found to have won the contract illegally, but the company was allowed to continue to pay out social grants for a period to allow a proper handover so that the payment of social grants was not disrupted. And the court did that because of the necessity, because there was no other solution. Could those be a precedent here?
I know. The Constitution actually makes clear that if legislation, ordinary legislation, or acts by, say, the awarding of a contract or whatever, if that is unconstitutional, it is unconstitutional from the moment that it happened, from the moment the act had been passed. But when the court orders it unconstitutional, they are permitted by the Constitution to suspend that order of invalidity for a certain period of time. This would be very different, because here what they want to suspend is not ordinary legislation or the actions of particular parties. They will be asked to suspend the very provision of the Constitution which you usually use to test for whether other legislation or acts are unconstitutional. And there is no provision in the Constitution to suspend a provision of the Constitution. There is a provision in the Constitution that says you can suspend order that ordinary legislation or acts are unconstitutional for a period, but that the two things are very different, because the Constitution is higher law, and the Constitution cannot be, the court has said in cases, a provision of the Constitution cannot be unconstitutional. Once it has been passed in an appropriate and prescribed format, it becomes law and it's binding and it's higher than any other law. So I don't know that argument.
Okay, now that does make sense to me now. Professor Pierre de Vos, Professor Ivor Sarakinsky, we'll continue this conversation in just a moment. The politics and the law around the possible postponement of the local government elections. Back with this conversation in a moment. Continuing our conversation for you on Newsfeed this afternoon about the legalities and the politics of the proposal to postpone the local government elections. The Electoral Commission saying today it accepted the recommendation of the Moseneke panel. As a result, it would ask a competent court, that'll be either the Electoral Court or the Constitutional Court, for permission to postpone the local elections until February next year. Professor Pierre de Vos is Constitutional Law Professor at University of Cape Town. Professor Ivor Sarakinsky is at the Wits School of Governance. Professor Sarakinsky, about an hour ago on Newsfeed, the Democratic Alliance spokesperson, Siviwe Gwagube, said that the DA, which has always opposed a postponement of the elections, might, and I mean let's stress the might, accept a delay until February on two conditions. Those two conditions would be that no precedent be set in this process and that a hard deadline be set by which the local government elections would be held. How important is the DA's attitude to this? It seems to me they're the one party that could go to court on this issue.
I'm not convinced that that is the conditions that they're setting are that relevant here, because the issue isn't at the discretion of political parties. And political parties always think that they have powers that they might not have. And this, I think, is a case in point. It's a constitutional issue. It either happens on time, and if it doesn't happen on time, then there's a problem. And the only way it can be delayed is to amend the Constitution. So the DA can form a voting bloc in Parliament to support a constitutional amendment to get the necessary percentages, and then they can put into that amendment all the necessary conditions that they mention. But without a constitutional amendment, a case could be made that the actual election, should it not be held before the end of October, is illegal and null and void. So this is not really, I think, what the main issue is.
I mean, on this issue of going to Parliament, I mean, that would be legally better. And Professor Sarakinsky, I'm putting this to you. I mean, politically, this would almost be a better outcome if Parliament could agree to change the Constitution. I mean, there are risks to that process as well. But I think you need 75%. That means all the major parties would have to agree. I can't remember the last time the EFF and the DA agreed on anything.
Yeah. And that's the only way to have a procedurally acceptable delay in the election. Other than that, the parties just have to accept that before October, in terms of the date that's set, they're going to have to modify the way they campaign. They're going to have to make sure they take advantage of all opportunities. As long as no parties are prevented through any repressive act from spreading their message, as long as the message comes out and citizens have access to information, it's free and fair in that sense. It's also free and fair if it's procedurally fair in terms of the voting process. And here it's quite easy. Masks, distancing, and you can even have outdoors, the boxes outdoors on sports fields at schools and community halls. And you just say, bring your own pencil. And I think that that's easily manageable. So I can't see how the constitutional amendment is going to pass muster even in terms of the criteria of free and fairness in the two aspects of free and fairness that are important here.
Professor De Vos, the Electoral Commission said today it doesn't know which court it will go to at this stage. It's still going to get legal advice. So, as I understand it, there really are two options. There's the Electoral Court, which has previously allowed the postponement of by-elections, sort of a different case, but the Electoral Court or the Constitutional Court. At this stage, do you have a view on which one would probably be the better court?
Yes, I can't imagine that they will go to the Electoral Court, because the Electoral Court, they are asking the court really, as I said, to suspend a provision of the Constitution. So the only court really that could remotely have the authority and the power to do so would be the Constitutional Court. So they will have to go to the Constitutional Court. They will have to ask for direct access. It has happened before. Other elections, like challenges to the exclusion of prisoners to vote, where the parties went directly to the Constitutional Court, and because the time was so short, the court heard the case with in a direct way. So that would probably be appropriate.
And just to sort of close off this point, I mean, some people might argue that there is a benefit to go to the Electoral Court first, because they can come to a decision, they can be a proper, I think the legal phrase is ventilation of the issue. Everyone can examine it. And if there's still unhappiness with that decision, you could go to the Constitutional Court after that. It would seem from what you're saying that that would probably be a waste of time. You'd go directly to the Constitutional Court.
Well, not only because it's a waste of time in that sense, but also because the time is running out. Courts take some time the papers need to be filed, the court has to decide and consider the matter, they have to write a judgment. These things take time. The Constitutional Court usually takes about 5 months to come with, to issue a judgment after a hearing. So there is no time left. So that if they're going to do it, they have to do it immediately.
Professor Sarakinsky, we have such a complicated political situation at the moment. We have a governing party with divisions, although those divisions seem to be shifting on an almost daily basis. The biggest opposition party well, shed votes in the last election, appears to be losing some support among certain groups. We have the next party, which doesn't appear to be growing, or there's very little evidence that it is. We have a couple of new players. I'm thinking of Herman Mashaba, Musi Maimane. It all comes in the middle of a pandemic. It all comes in a possible delay in this election. It seems really hard to predict what's going to happen. It seems hard to know if there'll be an election. It seems to be hard to know what the outcome of that election could be.
Yes, and that's why a decision has to be made very quickly to remove as many of these open-ended variables as possible so that parties can begin adapting to an extension if it's granted and happens, or if the date is cast in stone, and they start to innovate and start to campaign appropriately under the conditions of lockdown and COVID to get their message across. We just need certainty on that, bearing in mind that between 2014 and 2019, 7% drop in turnout. I expect we will have a similar normal drop in turnout at local government level from 58 to around 50. And anything below 50 could be explained in terms of the conditions of lockdown. But there is going to be a drop in turnout in terms of precedent. People have lost faith in public institutions, which complicates this even further. But the parties need to mobilize, get their message across, social media, WhatsApp groups, and I think a free and fair election is possible. Not a perfect one, not an ideal one, not a normal one, but a free and fair one nonetheless.
Professor Sarakinsky, does the timing of the election make much difference to the outcome, do you think? So, I mean, there are different ways to look at this. You could argue that an election campaign right now would be bad, say, for the ANC. It would be bad for the ANC because of what appear to be obvious divisions, the violence of last week, the question of former President Jacob Zuma is still going to be with us then. Should he get a pardon? Should he not? All of these will be big issues for the election. If I were an ANC internal strategist, I would argue this would be a good moment for an election because that can bring the party together.
There are pros and cons on all of this. It's also not clear what effect campaigning has on swinging voters either away from a party or towards a party. So there's a whole lot of noise, and citizens make decisions in that context. We shouldn't underestimate the collective intelligence of voters. They prove us wrong all the time because they're ahead of the curve, so to speak. So we just need to have an election. The Constitution says it. My view is let's just do it and see where it all ends up later.
Professor De Vos, I just want to sort of round off this point because this could be important later. Can the Constitutional Court in any way issue an order but not set a precedent? If one of the concerns is we're going to have a postponement of an election because of a pandemic, we're worried about the precedent that would set, can they explicitly say we issue this order but it's not a precedent? Is that possible?
Well, yeah, they're not really in those terms. I think they can do that, but it will be very difficult. What they would have to do, the rule that they establish will have to be so narrow and so stringent that it will be almost impossible ever to meet it again. So the problem is if they do that, then the current circumstances are probably not going to justify the election. And this is made worse by the fact that the Electoral Commission is really constitutionally obliged to take steps to make sure that there can be an election. They seem to be rather passive. Instead of proactively having gone out and registering people having voter registration when there was level 1 lockdown, all these things they haven't done so. So in a way they are now responding after the fact, while their obligation is proactively to take all the steps to make sure that there can be a free and fair election.
Professor Pierre De Vos, Professor of Constitutional Law at the University of Cape Town, Professor Ivor Sarakinsky at the Wits School of Governance. Thank you both very much indeed. A very complicated conversation. All I can say is I'm awfully glad I'm not a member of the Electoral Commission or of the Constitutional Court. I know you are too.